Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. And the legal disclaimer is that this podcast isn't legal advice. While I have to say this because the Florida Bar Association tells me I have to say this, I will tell you that nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. There are quite a lot of hot topics in the disability insurance world that I've been getting calls about. And today I'm going to be discussing these hot topics. And they primarily revolve around work issues. The work issue is, should you quit your job or should you apply for your short-term and long-term disability benefits now? What's the strategy behind this? Is quitting a good move or a bad move? What you might want to do instead of quitting? What you have to do before you change jobs to protect yourself from financial ruin? And what you need to do if you have pre-existing medical conditions before you make the decision to terminate your employment. We're also going to talk about what you should do if your employer tells you not to file for short and long-term disability benefits and just apply for your Social Security benefits, and the real truth about your human resources department. And then lastly, I'm going to talk about the 3 things you have to do before you apply for short and long-term disability benefits. These are questions that I'm getting every day in and day out, primarily because of the great resignation that's going on and people deciding whether or not they want to move on to what appears to be a greener pasture, when in fact it can be a financial disaster and a medical disaster by making the wrong decision. Let's take a break. Welcome back to part 2 of our discussion about whether you should quit, and if you aren't going to quit and shouldn't quit, what do you do about filing a claim for short and long-term disability benefits? In the last segment, we talked about the pre-existing condition issue that you might have that might prevent you from quitting your job. So let's expand that, because I see this problem arise, particularly in today's environment. When people are saying, this is an opportunity for me to change jobs. People are hiring. By the way, I like working from home. All the reasons that people are giving these days to terminate their employment and move on. So if you have a pre-existing condition, one of the things that you have to understand is that disability insurance plans or policies have a pre-existing condition limitation. And the problem that you have is that while a plan or policy can't necessarily deny coverage for a pre-existing condition, they can limit coverage. And they will use a policy provision called the pre-existing condition clause. So typically the plan or policy won't cover a pre-existing condition if you have seen a physician or gotten treatment for a pre-existing condition during a look-back period. So they can legally say if you've gotten this during the look-back period, that while you have coverage, your medical condition is excluded and you're not entitled to your disability benefits. So let me give you an example. Let's say you have Parkinson's and you leave your employer for a new job. You're part of the Great Resignation. You have signed up for short and long-term disability coverage within your new employer. And during the policy period, look-back period, you see a doctor or you get treatment. And then ultimately, you file a claim for short or long-term disability benefits because of the Parkinson's. What's going to happen to your claim? Now, disability carriers are looking for a reason to deny your claim. And one of the first denial tools is the pre-existing condition clause. You're going to look at your medical records and determine whether or not you saw a physician or got treatment for your pre-existing Parkinson's. And if so, whether you got that during what's called the look-back period. There's no uniform definition of a look-back period. They look at what the date your coverage became effective, and they'll look back for a certain period of time to see whether or not you got treatment and whether you became disabled within a certain period of time after getting the coverage. So let's add to this example that you are hired on January 1st, and the policy says, look, if you've got treatment in the 6 months before that, and then you file a claim for disability a year after you got your coverage, you are potentially going to be denied your benefits. So January 1st, 2022, your coverage becomes in effect, but the plan or policy says, look, if you got treatment 6 months before that, so in June of 2021 to December of 2021, your claim potentially could be denied if you file a disability claim within 1 year of January 1st, 2022, or in other words, January 1st, 2023. And again, as I've said, there's no uniform period of time for any of these particular periods. But the point I'm trying to make is that the disability carrier will look at your medical records and determine whether or not you saw a physician or got treatment for your pre-existing Parkinson's during that look-back period. And if you did, they will have a legitimate and completely legal way to deny your claim for disability benefits. And you should know that sort of stuff before you're part of the Great Resignation and move on, because that's a big impediment, in my view, to filing a claim, to resigning and moving on. Now, the reality is that you may not want to leave your employer, or you can't afford to leave your employer because you can't afford the COBRA coverage for your health insurance premium, and you can't afford the premium to convert your disability policy from an individual disability, from a group policy rather, to an individual disability policy. So I get that you might be burnt out, and I get you might be ready to switch it up with a new employer. But if you have a significant or potentially disabling medical condition, I don't think this is the time to switch jobs. I think that doing so really exposes yourself to financial ruin. So I'm often asked, well, what should I do if my employer tells me not to file a short or long-term disability claim? Just apply for Social Security benefits. Well, most employers are insured for their short-term disability package or benefits for their employees. That means that your benefits are coming out of their pocket. Every penny comes out of their pocket. And what are they trying to do? They're trying to have you resign, go away, get terminated, and then say, go apply for Social Security benefits. We don't really want you to apply for your short or long-term disability benefits. So if your employer tells you not to file a claim for short-term benefits, they're illegally interfering with your rights to your benefits, and potentially they can be sued. What's more important is the situation where your employer and your HR department says, look, I know you're having trouble. We're going to be nice. Why don't you reduce your hours to something below 30 hours? Now, why would they say that? Are they really being nice? Well, the answer is, hell no, they're not being nice. What they're trying to do is set you up to lose your coverage by suggesting that you reduce your hours to less than 30 hours per week. Why is that? Well, many policies say you have to be what's considered to be a full-time employee. And these policies, including your group insurance and your life insurance policy, and even your group health policy, may say that you need to be a full-time employee, which is more than 30 hours per week. So if your hours fall below 30, you can lose your group health, your life, your disability benefits. And in the process, they may also be setting you up for a termination. So the other game they may play is, look, they'll say, you're having trouble. We can reduce your hours. And when they reduce your hours and that doesn't work, they may say, why don't you just apply for Social Security benefits? We'll help you with that claim, or we'll support your claim. Well, guess what? As an ERISA disability and Social Security disability attorney, I can tell you it isn't easy to get Social Security benefits. And it can take as long, depending on where you live, as 30 months to get your benefits. So in the meantime, who's going to take care of your bills and your medical care? And what happens to you? Nobody's taking care of you, and it's certainly not your employer. And in the meantime, if you have terminated your employment and you didn't file a claim or didn't timely file a claim, you may lose your rights to your short and long-term disability benefits. So if your employer tries to give you the runaround and tells you not to apply for short or long-term disability, or tells you to just apply for Social Security or just quit, then you need an attorney immediately. your employer is trying to screw you out of your disability benefits. Now, I'm often asked, should I trust my employer to tell me the truth about my short and long-term disability claim? And that's not necessarily an easy question to answer, because some employers are truthful, but a lot of employers aren't truthful, but worse yet, they may believe what they tell you to be true because that's what they understood. And what they understood or what they were told by the agent isn't always correct. What's the real truth about your human resources department? The first thing I need to remind you is it's the human resources department. It's not the employee human resource department. The HR department works for your employer. They really don't work for you. Their job is to protect your employer from you. In other words, the HR department isn't your friend. Now, your employer may have offered you short or long-term insurance, and you signed it up because it sounded good, and they made it sound like it was a great thing. I mean, who wouldn't want to protect themselves from financial ruin? However, I can assure you that the HR department generally has no clue about the terms of the policy of the plan and how to file a winning disability insurance claim. I think that there are about 13 things they don't know. Often they don't know what the definition of disability is in the policy or plan. They don't know the definition of own occupation. They don't know the definition of any occupation. They don't know when the definition of disability changes from an inability to do your own occupation to any occupation. They don't know whether there's any policy limitations for subjective medical conditions like fibromyalgia, migraines, or body pain. They don't know if there's a policy limitation for mental nervous condition. They don't know whether or not you have to apply for Social Security disability benefits. They don't know whether your benefits are reduced by the receipt of Social Security disability benefits that you or your children might get, or whether your benefits are going to be reduced by workers' comp benefits, PIP benefits, the proceeds of a personal injury or a malpractice case, the withdrawal of pension benefits, and even other disability insurance benefits. And they certainly don't know what it takes to win a Social Security disability claim. They generally don't know how to protect your group health or life insurance benefits if you apply for your short and long-term disability benefits. They don't generally know whether you can reduce your hours without losing coverage, as I've discussed, or whether or not you have a residual disability claim if you lose wages. And they generally don't know whether your policy or plan requires that you and your employer attempt a workplace modification as part of the short and long-term disability claim and what's required. And what they don't know can kill your disability claim. And what they tell you may not be right. And that can kill your disability claim. In my view, you need help now, and you need help from someone who's in the trenches day in and day out dealing with these issues. Don't you think so? Let's take a break.